current clients. And we're going to see that the reason the next chapter follows so closely is there is a connection between current client conflicts and former client conflicts. Because even in some instances, even in one of the problems that we did in our last class, you have to look forward and backward at the same time. I'll give you an example of that. Because the current representation may conflict with something that you did previously, particularly in an instance where you have a former client. And a good example of that is when we talked about my client's subsidiary on page 299. You recall we were representing a client suing a bus company, and it came to be known that we were also suing an active client because Transport owned the bus company unbeknownst to us. So on some level, we're on both sides of the V. And the question was, how can we continue in this representation? But the key point in that case was, even if we withdrew from representing Dory Hathaway, what happens to her? We haven't done this yet, but she becomes a former client. We receive confidential information from her, and the former client expects undivided loyalty and protection of confidence as well. So we can't turn around and use that information to the disadvantage of that former client. We're going to see that when we talk about Rule 1.9c. So in that problem that we were doing, the client subsidiary, if we withdraw from representing Dory Hathaway, she becomes a former client. We receive confidential information against her. We cannot use that confidential information to her disadvantage. Then we asked the question, well, can we stay in with Transport? And we said not. We cannot use that information to disadvantage Hathaway as a former client. We've already established that, and we may be materially limited in continuing our representation of Transport because we can't use that good information that we have on Dory Hathaway to advance our current client Transport's interests. And Transport might say, well, you're going to be limited in all the things you can do. Why can't you use this information? And there's also the possibility of an amended complaint in order to advance this action. So we concluded that you have to get out of the boat. Then we went through a series of problems, police brutality 1, 2, and 3. And one thing that we did, starting on page 308, was, this is scene 1, was to try and figure out how does joint representation work. A lot of moving parts. We have a joint representation, 2 clients. We have a person who has confessed to the crime, who's a police officer. We have someone who may be involved, who is an officer of the PBA. We represent the PBA and its membership. We have an installment contract that is renewable based upon the PBA's evaluation of our work. So if they're satisfied, they're going to keep us on, and that's $10 million in the balance. And then we looked at all the possible conflicts. There's also a civil action, Austin against PBA. And even though we don't represent PBA in that case, we still represent PBA as an organization and its individual members in other litigation that they may have under this installment contract. So we talked about a joint representation agreement and whether or not this is consentable. Throughout these problems, we were talking about whether or not it's consentable. And there's a number of things that run through this joint criminal representation. The co-defendants may shift blame, helping one client to hurt another. So you have these co-defendants, we represent both in our firm, and we have to make a decision one over the other. That's a true sign of a conflict. Can we effectively cross-examine if necessary? Might cross-examine the client, that's bad. And we might reveal information that inculpates one by exonerating another. So all those are things that we have to look at. Also, Austin, who is the victim of the assault, says that at least one other person participated. So that can mean one of our clients points the finger at each other. And then what about Gutman? We cannot maybe aggressively cross-examine without hurting one of our clients. And the defendant may reveal a confidence that we should reveal but can't because we might hurt the other client. So a number of different things that we looked at. And that brought us all the way up to 7.4 on page 310, the police brutality scene 3. And so after we sort of established all these points, I think we're left with what we have on page 310 and 311. That's where we left off. So I guess these questions are, and I think we left with this, should we present the testimony of the officers who say that Gutman was involved in the assault? Now remember, Gutman is separately represented. He's not our client, but we do represent the PBA, and Gutman is an officer of the PBA. And we want to make sure that we can move forward. And so, you guys have this, what do you think?
I just want to ask a question.
A little bit louder.
I just want to clarify. When you say represent the organization, not necessarily like the individuals within it. Like with the NBC, like where we represent the organization and you not necessarily the president.
Yeah, well, I think this is part of the agreement in the fact we represent PBA and some individual members as well, but not in this litigation, Austin against PBA. So we can do both, and we have consent to do that. We consent with everybody. We talked to Stone, we talked to the other client, we talked to PBA. So think of we're representing everybody in this hypo.
There's no way you can represent every single person in a hypo without hurting somebody else.
Mm-hmm.
There's no way.
Mm-hmm. So should we? But okay, we have this information. Should we use it? That's what I meant. Yeah.
I wish I'd like to say yes, you can't, because it would exculpate somebody who you now represent because of that contract.
So notice this is back to my point. Yes, but assume that the firm has signed a PBA contract and has agreed to represent all PBA members who are accused of misconduct. So we represent them, and you see at the top of page 310, the PBA offers our firm a 2-year contract for $10 million to represent all PBA members and to represent PBA itself in any litigation. And then it says including the Austin case, but we ultimately don't represent Austin in that case. So we represent everybody. And we have this information that Gutman is probably the other officer, and we have to make a decision whether or not we want to use it. And this officer says there's no way to really do that without hurting one of the clients. Well, both of our clients would be exonerated or at least face less criminal liability. So why shouldn't we just use this information? Should you present the testimony of the officers who say they saw Gutman going towards the bathroom with Austin? If the answer to that is yes, what are the consequences of doing that? Okay. Gutman is separately represented. So we represent our 2 clients, Stone and Morton, and that's what we want to get off. So why should we give up this information? And so notice how the question sort of takes you through this. Yeah, we probably should do this. This helps both of our clients. We're not turning against each other, but we have PBA to consider. Even though they're separate, we have some connection to them. We represent them in other matters of misconduct, may even represent the organization. So notice the second question. If we decide to present this testimony, should we tell PBA about this testimony so that the officers don't feel blindsided? by the way, we represent our own two clients. We don't represent you, PBA, in this particular instance, but we really need to present this testimony against Gutman. It will help us advance our defense, and we're going to do so. So would you warn PBA that you want to present this testimony? Look it up.
You could get them all to consent, but
Tell me why you think you can give them. That's interesting.
I don't know if it's consent, but
Yeah. So tell me why you say you don't know if it's consentable. This background makes me really nervous. I'm really, wow.
Yeah.
All of this stuff.
I think the amount of money that you're getting paid by PBA is like
That's a lot of money.
the catching point.
Yeah. So notice what that much money does to you. Now you've taken professional responsibility, passed the NPR, you passed the bar, but you had this $10 million in the back of your mind. So you even look at the rules. You look at 1.7, you look at 1.9, and you start rationalizing. Well, I can get informed, I can talk to my clients, and everything will be okay. We can get it confirmed in writing. And so there are practical consequences to this because we're asking the question, is this really consentable? So notice what happens if you forewarn the PBA. What do you think is going to happen? Governor's on the board. He's going to find out. He's going to start leaning on people, and they are probably going to impose this code of silence. PBA is going to get mad at you. We really don't like your performance. We're canceling the contract, and so that impacts things. Or you may rationalize it so much that you're not really looking at the full critical consequences of this conflict. So notice that this is what happens in the actual case. So your client, who's also a member of the PBA, they say, well, no, don't worry about it. We have one officer who admitted to this, Babbage. And our defense will be he did. He did it by himself. We don't know, somebody else could have been in there, whatever. Don't say anything about Gutman because the PBA might get angry at us. We want them to continue paying our fees. And so you just advance the defense that Babbage did it along with somebody else, and we really don't know. That's on the middle of page 311. So Stone tells you that he doesn't want to introduce the testimony of other officers because he doesn't want to get in trouble with the PBA or Gutman. We as attorneys agreed to defer on this. And together we decided to rely on the theory that Officer Babbage, who already pleaded guilty, acted alone. Of course, our client goes to trial, you know what happened, found guilty. Found guilty. And this is after waiving the conflict. So in the real case, the court cautions the defendant about waiving things. And on open record, this is what the defendant said. The judge and an independent lawyer did advise the defendant about the conflict of interest. He agreed to waive any objections to the conflict, and he wants to continue with his lawyer, us as the law firm. And this is what he says on the record. I understand that with this case, there may be some potential conflicts of interest, one being that my attorney and my co-defendant's attorney are now with the same firm. This is a conflict in that one defendant may receive a better defense at the expense of the other defendant. I'm also aware of my attorney's contract with the PBA. I know that there's another conflict with that, he says, and that the government may call other police officers who are members of the PBA, or even PBA officials. There's a concern that possibly my attorney may have another agenda and may be less vigorous in his cross-examination of these witnesses. I'm also aware, he says, of calling witnesses with potential conflict with two lawyers in the same firm. If they call a witness, who my lawyer may be reluctant to call as a witness, that may be harmful to another defendant. I understand that there may be a conflict with that. So all of this is in open court. I understand. We refer to his decision in appointing Babbage. The judge expresses concern that we have a conflict of interest arising out of our conflict with PBA. Our client says he understands everything, waives any objection, and despite our argument that Babbage acts alone, our client is found guilty. Now you know what he does now, ineffective assistance of counsel. You should have considered everything, you were materially limited, you didn't put on the right defense and aggressively pursue that defense because you were worried about losing the PBA contract. Is he likely to prevail and have his conviction reversed? That's on the bottom of page 311. That's the major question after three versions of this problem. First, we looked at joint representation itself. Then we added another layer when we took on PBA as a client and its members, as well as that civil lawsuit, Austin against PBA. And now we're at the point where we've gone to trial. The defendant in open court says, I waive everything. And the question is this consentable? Actual Second Circuit case that happened about 18 years ago. What do you think happened? Was the conflict of interest waivable? Was this conflict consentable? What do you say? Are you fooled by the fact that you have someone in open court saying, I waive everything, I understand, I want to move forward, that's fine. And then, of course, when you get convicted, you come back around and say, oh, ineffective assistance of counsel. So what do you think happened in real life? Second Circuit case.
I don't think this is just because these conflicts are accessible because there are way too many people that you're representing and way too many interests that go against one another.
Okay, so
And I don't think that I don't think what he said is when I personally understand this. I'm not sure he did because of the way it's worded. It contains words that stretch that sound more like legal jargon. It sounds almost like it sounded scripted.
oh yeah, it probably was, but this other police officer, he understood pretty well. He understood pretty well. It wasn't like, I see what you're suggesting, a lot of legalese, and he thought, but you know, as far as informed consent being a critical assessment of pros and cons, he certainly understood that, and he understood that he needed his legal fees paid, and he was just like, this is what I'm going to do. But I think you're right about whether or not it's consentable or not. What do you think the court said?
It's not consentable.
Not consentable. This is a case, the Abner Louima case. It happened in New York, and so a number of different things happened. So the Second Circuit reversed the conviction. It found that the attorney's conflict of interest was not waivable. And so this is an example of a current conflict that you cannot paper over. I mean, it looks like informed consent, you have him in open court saying this, but the Second Circuit looked at this and said, this is fundamental to the attorney-client relationship. The most severe conflict, the court noted, was the attorney's interest in keeping and renewing this $10 million retainer agreement with the PBA. So under that contract, you recall from the fact, the PBA had the right to cancel the agreement. And so the court concluded that the attorney's self-interest was so strong that, quote, no rational defendant in this position would have knowingly and intelligently desired the attorney's representation. And then the attorney comes back and says, oh yeah, I support the Second Circuit decision. I'm pleased with the result, although I feel the court reached the result for the wrong reason. I've always believed in the defendant's, my client's innocence, but I don't feel there was a conflict of interest regarding his representation. Yeah. So the officer was later retried. He's convicted of perjury and sentenced to 5 years. Then later on, he started work for Con Ed, Consolidated Edison, the electric company in New York. He was fired because of his criminal record, and then there was a lawsuit against Con Ed. I don't know what happened in the lawsuit. In the actual case, the victim in this case, Abner Luima, he received $7 million from New York, $2 million from the PDA. They reevaluated the code of silence, and now when you have this police officer case where there's a conflict, you have independent outside lawyers in cases of conflict with the PDA. So the Second Circuit concluded that this was non-consentable. And that's an example. Just because you have something written down on paper does not mean that it's consentable. And as all of you pointed out, there's really no way to provide effective representation. The fact that you cannot even talk about Gutman in terms of being the other alleged assailant shows you that it's a conflict that materially limits your ability to pursue all options on behalf of the client. So the client is not getting full representation because of that conflict. Okay, that's the police case. Look on page 313, representing the McCarthy. Now this is interesting. This is problem 7.5 on 313. Still a current conflict. And these problems are set up to sort of say, you have to be careful. Now this conflict sort of comes out of the names being spelled wrong. And then we don't realize that we are, again, in a position where we are suing one of our clients. So here we still have a joint representation. And we have this scenario. We have a will that we are doing. And we represent you. This is estate planning. And that's fine. Part of the estate is going to one spouse or the other. Part of it is held in trust for the children. And that's good. And then there's this paternity suit. Maureen Carr versus Hugh McCarthy. He's represented by new attorney. So our firm, King and Drogula, we represent Hugh and Jolene in estate planning, and we also represent Maureen Carr against Hugh McCarthy, our client in the will context, and we're suing him in the paternity suit. And so, information will be shared, our confidences will be shared. There's a joint representation agreement, and we lay out everything. They sign this letter about possible conflict of interest that are inherent in terms of the joint representation. So you see over and over in this chapter, current client conflicts are really exemplified when you have this joint representation. So things start off with a common purpose and then interests diverge. So the letter explained the effect of the will disposition. Also explained that information disclosed to the firm by one spouse could become available to the other. I mean, it really should say that you share all of this in the joint representation. They also signed at the top of 314, a continuing retainer, small fee. They are still being advised on matters as we move forward that impact the estate planning. And then we had a problem with a misspelled name in terms of the conflicts database. So we don't pick up when we take on Maureen Carr as a client that Hugh McCarthy is our actual client because McCarthy is spelled with an A in our database rather than just MC. Our client, Hugh McCarthy, really doesn't recognize this as a conflict. And that can happen in real life. He just thinks, well, they represented me in the will contest, I'll just get a different attorney. That'll be a separate matter, unrelated. See how the layperson is sort of analyzing it. And it's not really a problem if I keep this separate. But Hugh McCarthy really just wants to say, I don't want this information to come out. So he really doesn't recognize that there is a conflict. The problem even says he's not a lawyer and has no training in conflicts of interest. So then we go through all this, and Hugh, through DNA testing, is the father. Now here are the series of questions. The conflict comes to light when Maureen Carr's lawyer, Kenny, our partner, asked Bucci for the information, and he sort of cynically, with a smirk on his face, said, you already have the information because you represent the client that you're suing, really explicitly is what he's saying. So we get off the phone with our partner who told us that he's representing Maureen Carr in a paternity suit against Hugh McCarthy. Now what? Does the firm have a conflict of interest? So we're just going 1.7 all over again. We always say, well, is there a conflict of interest? How do we define that? Is it directly adverse, or is representation materially limited? We have one of those or both of those. We have a conflict, and then the question is the conflict consentable? So what do we do with this problem? I mean, who we need consent from? And notice how that works with confidences too. In order to have informed consent, everyone has to be on the same page. We have to know everything, and then we make the decision about whether or not this representation can continue. So we're in this mess. What do we have to do? I mean, you can really, in real life, just start talking and then see if this is consentable or not. It'll probably become apparent right away that you might not be able to move forward with this. What do we have to do? I mean, is there any way to have a good conversation here with the affected clients? Because we definitely have to talk to Hugh and Jolene, right? They're our clients. But Maureen is our client too. And then what do we tell in terms of confidence? I mean, Maureen might want full disclosure to push it. Hugh certainly doesn't. And Jolene will just be blindsided. So, do you think this conflict is consentable? No, I don't know. Bad conversation. I mean, you would probably just talk to Hugh and then, no, I can't, and then that would tell you that this probably isn't consentable because this fact that he wants to keep a confidence, and we have a duty to, would have to be disclosed to the other client. So that shows a conflict. And so the next question sort of clues us into that. Assume that the conflict is not consentable. May Kenny and Drew continue representing one or two of these clients, or must it withdraw from representing all three? So can we do it like this? We tell Hugh, no, we can't bother with you anyway. We don't like you and you've done some bad things, and we just want to get away from you. So we're going to just continue representing Jolene. We'll keep everything quiet on your end. We're not going to tell Jolene anything, but we want to get away from you. We were terminating our representation. And we continue to represent Jolene and Maureen Carr. Is that good enough? And we say you're on the other side of the V anyway in a paternity suit, so it's better that we are part company, but we're going to stay with Jolene. Yes?
I feel like it's going to be limited because, like, all the stuff that Hugh's done is going to affect Jolene. Like, if she knew about that, she's going to want to change her will.
Yeah.
So, that's by not telling her that, you're going to be hurting her. And then
You can't even effectively plan because you can't tell her that. And so you're keeping a secret from her, still working on estate planning with sort of partial information. That's materially limited as well. Go ahead, that's good.
And then, like with Carr, you already have like a lot of their financial information for Hugh, so that could be used to kind of get an upper hand in like negotiations, maybe, or settlement offers.
Yeah.
So that could come into play too.
That's good. That's the killer. So we get all of this information. And you notice that even when we're talking about prospective clients, we have a duty to keep that information confidential. That is the core of the attorney-client relationship. So notice, from all of this representation, the firm has confidential information from the McCarthys that the firm could use to materially advance Carr's position. We could use this information to harm the McCarthys as former clients. So we would harm you, even if we kept Jolene on, we'd be harming her because we can't divulge the true information that we have in terms of the confidences. And so that would mean that we'd probably, certainly withdraw from representing all three parties. There's no way to keep on because of these confidences that we gain. And you know, we're going to see from Rule 1.9c, if we have this information, we cannot use it to disadvantage our former client. So the last thing in this chapter, just to go quickly, is have any of you had any experience with insurance companies and who's the client? Any practical? No? Okay, so this is what they call the insurance triangle. See on page 315? So you have the insurance company up here, and then you have the attorney and the client. But then there's some question about, is the insurance company the client as well? Book tells you insured is always the client, but the reason this is in the conflict section is if you have the insurance company as the client too, how do you balance those interests? And there may come a time when you cannot balance those interests, and that's what this section talks about. So the insurance company can provide the insured with a lawyer, but we know under 1.8, you see that on 317, that just because the insurance company is providing a lawyer doesn't mean that the insurance company can intervene in that representation. But practical reality probably will, and then that could lead to the lawyer withdrawing if the lawyer cannot maintain independent professional judgment. So who is the client? It says on page 316. The insured is always the client, you know that, but the insurance company may or may not be depending upon the contract and state law. So you even see an example here. In one case, a lawyer learned that an assault on the child had been intentional and therefore would not be covered by the insurance policy. The court held that the lawyer was obliged to keep the information confidential and to withdraw from representing the party. There also could be a situation where the damage award exceeds the coverage amount, and then a conflict could exist. Who's going to pay for what? The insurance company turns on the insurer. So this section makes the point that we have to act in the best interest of the insurer. So, and then if you cannot act in the interest of the insured in such a way and balance that with obligations to the insurance company, this section tells you that you should withdraw from both. So the lawyer's professional obligations to the insured should govern the lawyer's conduct and settlement disputes. Finally, you see on top of page 319. So there may be a disagreement about insurance limits, claims in the policy, and the insured and the insurance company can't come to agreement about what is covered or not. If the insured rejects claims that are within the policy limits and the insurance company really doesn't like this, the insured may have to hire another lawyer at her own expense. So that's a disagreement about policy coverage, and the insurance company says, we're not paying your attorney. You have to cover that. And then finally, an insurer is often required to cover legal expenses when it turns down a settlement and damages that are in excess of the policy limits. So this is sort of like the last part of the chapter, but it just shows that there may be conflicts based upon who is the client. The insured is always the client, but then the question is how much leverage does the insurance company have? So that is current representation. We've done just regular current representation. In this last section that we were talking about, the special applications of the current client conflict situation. Now we're going to move into former representation. So it's important to set out, so you'll be able to identify these scenarios, what situation we're in. And that's important because you have to figure out, does 1.7 apply or 1.9 apply? That's important because, as we've seen, the current client requirements are much stricter than former client. I mean, the rules are constructed in such a way that we really care about the current representation. Not to say that we don't care at all about former representation, but the standards are a little bit looser when we talk about former representation. So the past scenario that we talked about, concurrent conflicts, this is 1.7. You have this scenario. You have two present clients. That's why we did so many joint representations. So when we represented the two criminal defendants, or we represented the McCarthy, two present clients, either separately or joint representation. Or another scenario, and this is what we did, you could have one prospective client. So notice that's the situation where we get all the information, we're moving forward, but we already represent someone, and those interests may be directly adverse to who we're talking to become a client. So you have prospective client and one present client. So that's that scenario. You have a joint representation, you could have, you're representing different clients at the same time, a conflict may arise, or you may be trying to develop an attorney-client relationship through a prospective client, and that conflicts with someone you already represent. This is just the first paragraph of the chapter. This is broken down. And then, but now what we're talking about, former client or successive representation is what we're talking about. And so this scenario, this is going to help us break down this rule. This rule has three essential components that we're going to be looking at: 1.9a, 1.9b, and 1.9c. We sort of been talking about those implicitly, but now we're going to explicitly go into the analysis of former clients. This is chapter 8. So the former client scenario, you have one present. So you recall in the hypos, we would say, well, why don't we get rid of this particular client? And all of you accurately point out, well, that would be a former client, and then duties attached there as well. So the scenario that we're talking about now is we have a current client or a prospective client. So we're in the present, but we have to look back because we have to look at what we did previously, and does that create a conflict? In other words, what we're doing currently, does that impact something that we've done before? Does it undermine the former representation? Because even our former clients should expect that we won't undo something that we've done in the past. So this rule 1.9 is going to cause us to really examine representation. So we start off like we always do. You see on page 324 there's a chart, but this book is better. So use both. The chart is a good summary, and then you plug it back into the rule book. But tell me what you think this rule does. Look at 1.9a. Duties to former client. So you represent someone now, and you're concerned that something that you did in the past might be impacted by the current representation, might be negatively impacted by the current representation. And you consult this rule. So take this rule apart, tell me how it works. How does it work? What does it say? Because there are different levels. This is a current representation. Then 1.9b, we're going to see what happens if you work one place and then you move someone somewhere else, and you used to work on something in the past. Now you're currently working on something that your new firm. Does that negatively impact the former representation? Then we're going to see 1.9c, which is a blanket prohibition. You cannot use information that you gain in this former representation to the disadvantage of that former client. But we're just starting with 1.9a. How does it work? What does it say? Miss Manning, tell me, what do you think? Is there Miss Manning? She's not here.
Oh, Kurt.
Oh, jacked up. Anyway, Ms. Boyd.
So essentially, it says that for a client you formally represented, you shouldn't represent another client after that.
Okay. So we got that's the first part. So we formally represented the client in a matter. So we have to figure out matter, but that's just this could be a transaction. It could be a contract. It could be advice. Whole host of things. So we formally represented in a matter. So not thereafter, they represent another person in the same or substantially related matter. So how do we know that? We're same or substantially related matter. Same is easy. I guess we used to work for NBC, and we negotiated a number of different contracts for Saturday Night Live. And then ABC is starting a new late night program, and we started working for them, but there's some overlap in terms of the information that we could use. Could that be something that's substantially related? How do we know something's substantially related? And if it is, then we're going to have to get informed consent from NBC. How do we know something? So the same would be, you negotiate a contract for one client, and then you go to the other side, and you're trying to undo the contract that you did. Same contract, you're just working for somebody else, and you're undoing what you did in the form of representation. That's the exact same transaction. But substantially related seems to be a little bit more difficult to define. How do you look at that?
It's substantially related if they involve the same transaction or legal dispute, or if there's a substantial risk that confidential factual information that would have been obtained in that prior representation could advance or affect your new client's representation.
Yeah, what's all that mean?
So if it's substantially related, like in that past case, maybe there were some facts there that could help you in this case with this new client.
Okay, good. So they give a nice little short example. You look in the middle of comment 3, it says, for example, a lawyer who has represented a business person and learned extensive private financial information about that person may not then represent that person's spouse in seeking a divorce. So again, don't get fooled by unrelated. He just represented the business person on business matters. No, this is substantially related because the information gained in the form of representation can be used to the disadvantage of that client. And so, therefore, the same transaction or legal dispute, or if there otherwise it's a substantial risk that, as Ms. Boyd points out, confidential factual information as would normally have been obtained in the prior representation, but materially advance the client's position in the subsequent matter. So taking information that you learned formally to advance the current client's interest at the expense of your former client. So that's interesting. But notice this in comment 3, when you look at Rule 1.9a, we're talking about, this is what really drives this. We're talking about confidential information that a lawyer normally would obtain in the representation. So this is a presumption, not the actual information or anything. We're presuming that if you are involved in this type of representation, you came across this type of information. So notice even in the hypo, we talk about that business person. Well, if you're representing this person in business transaction and that type of thing, you will come up with private information that could be used against that former client in a divorce action. So if you look at comment 3, and we're using this presumption so that the former client does not necessarily have to reveal confidential information to establish a conflict. We want to protect that former client. So we're talking about confidential. This is from comment 3, information that a lawyer normally would obtain in the representation. Talk about the former representation. And so what we're emphasizing now is that there are continuing duties to the client. And so notice what I just said. A former client is not required to reveal the confidential information learned by the lawyer in order to establish a substantial risk that the lawyer has confidential information to use in a subsequent matter. So we're making this conclusion, the rule goes on, about the possession of this information based upon the nature of services that were provided in that former representation to the former client. So this is a presumption really to protect the former client. That's letter A. But there's one other thing here that we have to look at. We have to look at a matter, and comment 2 tells us what that matter is. And so we're going to make some factual determination about the involvement of the attorney in that matter, whether or not that establishes a conflict. The underlying question is whether the lawyer was so involved in the matter that the subsequent representation can justly be regarded as changing of sides in the matter in question. So none of these we're going to look at how much involvement the attorney had. And then finally, what is materially adverse? And how is that different than directly adverse? Is there some definition in the rule? How do we know what materially adverse is? Look at the book on page 341. Neither rule 1.9 nor the comments define material adversity. And we have 1.7 using language directly adverse. So, what is materially adverse? It's interesting that there's no definition of it in the rule of the comments. So how do we know? Yeah, I don't know something materially adverse. Is it the same thing as directly adverse? Yes.
It's not the same as direct
Right.
because they probably use two things.
Right. So what do you think the difference is?
Maybe level of severity.
Uh-huh. But what do you mean level of severity?
You know, if you're material adverse, then you can consent to get out of that, whereas it's directly adverse, you can't.
And it seems like you should always be able to get consent in a former representation compared to a current representation. Materially adverse, the book says, is probably less restrictive. And I guess the question you're asking is, notice this, it says that the apparent intention of the rule is to require consent if the use of the former client's confidences might harm the former client's interest. So if the subsequent use of this information would not harm the former client's interest, then we don't really need consent. But I guess the question is, we're talking about materially adverse. The question is, would the use of former client's confidences harm the former client's interest? So there's no definition in the rule or the comments, but we know that it's something that goes against our former client's interest. So that's 1.9a. We know that it does a number of things. It talks about current representation. It's something that we're doing currently materially adverse to something we did in the past. What we did in the past is the same transaction or something substantially related. And there is a presumption that we have continuing duties to the former client, and the information that we're talking about in comment 3 is confidential information that a lawyer normally would have obtained in the representation. So it's a presumption based upon the type of services that the lawyer rendered. 1.9b is something different though. What happens in 1.9b? So in 1.9 we are comparing what we're doing currently to something we did in the past. 1.9b we're doing the same thing, but we made a move. We moved to a different firm. So what about 1.9b? What does it say? How does it apply? Yeah.
So you can't represent a client in the same matter that you did in the previous firm.
Okay. Well, elaborate upon it. So, you say can't represent, but why can't you represent? This is sort of broken down. So, the first part it says, a lawyer shall not, this is what you're talking about, shall not. So we still have represent a person. We're still in the same or substantially related matter. So we're carrying that over. In which a firm, the previous firm, with which the lawyer formerly was associated with, so in this previous firm, the lawyer who is at this other new firm previously represented a client. Still had the same or substantially related matter. So a lawyer shall not represent a person in the same substantially related matter in which a firm with which the lawyer formerly was associated had previously represented a client. And you have these conditions: materially adverse again, and acquired information protected. 1.6 and 1.9c. That is material to the matter. So what does this mean? And so, and this again, unless the former client gives informed consent. So what's the difference between this and 1.9a? You know, it's looser. Did the former client can give informed consent, we move on, that's fine. But what's the difference between 1.9a and 1.9b? The analysis. So here we're staying put, we're just looking at what we're doing presently and in the past, whether or not there's a conflict. Here we move, we've done something in the past, we have this new firm. The question is, can this new firm take on this action? Yes, go ahead.
I just have a question
Yeah.
why they include knowingly in B instead and it's not included in A. Are they like implying that there's a scenario where like maybe you weren't aware that the firm you were at before represented this person and so like you're not aware of the conflict maybe? But then like the subsection 2 kind of counteracts that also because you have to get information.
Yeah.
So like
That's good. So, yeah. That's good. That's the difference between 1.9a and b, the type of information. So tell me what you're about to say, the type of information. Go ahead. Knowing, yeah, that's right.
Well, like, I guess you have to get information that was like confidential, and then you can't use that for your current. But like, why do they include? If you have confidential information, you obviously know. So why do they include the knowingly on top of that?
To distinguish 1.9a from 1.9b, the type of information we're talking about is different.
Oh.
Tell me, you're saying it, but I want you to say this. How's the information different? Because that's what you're getting at. You say knowingly, they must know, and you're looking at what they worked on. We're doing the same analysis, but we're saying you move from this firm, but we want to measure how much involvement you had, how much you actually knew.
Right. This one, B required like explicitly says that it's information that's confidential in 1.6, and that's not included in A.
Yeah.
Which is of any material adverse information.
And so notice what this is actual information that the lawyer might have. Notice 1.9a, that's just a presumption. We're talking about the type of information that you would normally have within those services. But 1.9b, we make it knowingly because we want to do two things. We want to, of course, preserve undivided loyalty to the former client, preserve those confidences, but we also want to make sure that lawyers are not crippled in terms of moving from place to place and not frozen in time. If this rule was really expansive, whenever you moved and you were involved in something the same or substantially related, the entire firm would be conflicted out. Remember, we're one lawyer for the purposes of the rule. So imputation will come in place and then you can never accept anything. So now we have to look at actually having this information. And where did I get that from? Look at comment 5. That's a good one, comment 5. And so this is interesting. This explains Ms. Sharp's point. And it is this. Comment 5. Okay. So paragraph B, which is what we're talking about, operates to disqualify the lawyer only when the lawyer involved has actual knowledge of information protected by 1.6 and 1.9c. So notice, I can move over. Let's say I was in the Justice Department. I worked for the Office of Federal Thrift, and we were looking at savings and loans, and I was prosecuting fraudulent transactions in the savings and loans industry. I moved over to a new defense firm for corporate entities, and I'm in the same matter. But I moved over from the government. I'm in this new firm. Then the question would be, would I be materially adverse in advancing this defense against my former co-client, the government, and did I acquire information protected by 1.6 and 1.9, which could be used to the disadvantage of the government? Now, the government can give consent, and that freely happens when someone moves over from the government to a private practice. But before we even get to that, the question would be how much I worked on it. So maybe in the same matter, I did an hour and a half's worth of research, and I wrote a one-paragraph memorandum saying, this is how I interpret the statute, and that's it. But in this same litigation, and it goes on and on, I move over to the next firm, and then there is some discussion about whether or not my new firm should be disqualified. And the court looking at that would say, well, yeah, that's actual information, but does that warrant disqualification? Do you think it would warrant disqualification? Hour and a half of research, one paragraph memo. Would that disqualify me? So I make it a little bit more difficult. If you look at comment 5, it says, if a lawyer while with one firm acquired no knowledge or information related to a particular client of the firm, and that lawyer later joined another firm, neither the lawyer individually nor the second firm is disqualified from representing another client in the same or related matter. But I changed a little bit. I did a little bit of work before I moved to my other firm. Do you think that would disqualify my new firm? What do you think? Ms. Moore, what do you think? Yeah, it depends. But hour and a half. I pulled up some cases. I wrote a little note. It's the same matter. I move over to private practice, and then somehow a disqualification motion is filed, and we have to look at Rule 1.9b. I moved over. Lawyers shall not knowingly represent a person in the same substantially related matter.
You're saying it's the same matter.
Oh, it's the same everything. I just did 1 hour's worth of work and a little bit of research, and someone wants to disqualify my firm based upon that work. Is that enough actual knowledge to disqualify a firm? Yes.
I don't think so.
Yeah.
Not as general research. I mean, that means like any knowledge that you gained throughout your career would prohibit you from practicing in any of those situations again.
Yeah, yeah.
It would have to be information that would protect that or 1.6.
Yeah. That's good. And so, and that just illustrates it's fact specific. You know, just a little bit of research on this, probably not a confidence. It could be information that could be used against the government, but I doubt that even. 1.9 really illustrates that you have to look at the facts and see how much level of involvement the attorney has. So we need actual knowledge, and we're going to look at, if you look at comment 6, it depends on the situation's particular facts, aided by inferences, deductions, or working presumptions that reasonably be made about the way in which lawyers work together. So if I'm looking at how I used to work in the government, a senior in the email said, have them do a memo, I'll look at it later. I spent an hour and a half worth of work, I did the cases, write my little paragraph in the foot. That's the time that I'm with the government, I don't do anything else. Then I move over to the private firm. I'm going to say that's not likely to disqualify. A lawyer may have just general access. So, let's go look at this problem on page 343 to start off. Oh, so before I even do that, so look at this on page 336. This is a little case called Silver Chrysler Plymouth versus Chrysler Motors Corporation. The court there declined to disqualify. Now notice this. This is the same type of thing that we did, based upon a lawyer's work as an associate at a previous firm. So notice this is in the middle of the paragraph. There was testimony that when a lawyer was an associate at his previous firm, he did not work directly or indirectly on Chrysler dealer litigation, with the possible exception of researching a few specific points of law that may have been involved in the dealer case. So that could be the same, but we're looking at actual involvement in what they did. The court declined to presume that the former associate had been exposed to confidences possessed by other lawyers in his firm. Therefore, the matters were not found to be substantially related. So we're looking at actual activities in specific cases, which would make it reasonable to infer that the attorney came in contact with this information. Either the presumption, if we're at the same firm, or actual knowledge, if we are talking about an attorney moving from one firm to another. That's good. So, look at this one problem on page 343. Keep it in touch. So this is just going to help us figure out if someone is a former client and is this the same or substantially related matter. So 343. So we worked for a law firm that 5 years ago did work for a company called Allman Enterprises. Our prior work was to provide an opinion on tax consequences of purchasing certain bonds. We worked on it for 1 day, and Allman paid us the amount of $2,500. And our firm continues, as most firms do, to send out an annual newsletter of all of our previous clients as well as current clients. You know, that's good marketing, as well as good information for our current clients and our past clients, and we want to keep in touch. Title of the problem. The newsletter alerts recipients to changes in tax law and other laws that might affect small businesses. So we usually say this is a new tax legislation passed by Congress. It could impact accounts like yours in this way. If you have any questions, call us. That's something like that. The firm also called Allman Enterprises several times over the years to ask whether or not it needed additional services, and the company always said, no, thank you. Thanks for calling, but we don't need anything. Now, Star Information wants us to sue Allman for unpaid bills, 40 hours of consulting fees that we have not been paid for. They come to us and they want our representation. The computer consulting services have nothing to do with the bond work that we did for Allman 5 years ago. And we are asked to assess whether any present or prior work creates a conflict of interest that precludes our representation of Star Information Systems against Allman. So our preliminary review suggests that the only problem relates to our previous work for Allman Enterprises. We have to evaluate whether Allman is a current client. If it's a current client, notice this, the book even tells you. If it's 1.7, the standards are a lot more stringent than former representation. So is Allman a current client? Or is Allman a former client? In case 1.9 would apply. So notice, this is just an example of what we've been doing most of the day. So looking at factual circumstances and then making an assessment about whether or not a client is a current or former client. What do you think? Is Allman a current client? Current client? Yeah.
I say they're not.
Why not?
Even though you are listening, like there's like really some that with current and former clients, and every time you ask them to services, they always decline.
Okay. What about us sending a newsletter and all that? Is that like a continuing relationship? That's what we send a newsletter?
That's another person.
Okay. Even though our current clients are receiving the newsletter too? Okay. So, not a current client. Our work for them concluded. It was only 1 day. We were paid for that. Everything's fine. Not a current client. What about a former client? Former client? And so just because it's a former client doesn't mean that we can't represent, we can get informed consent, or could be a former client, but this doesn't apply because we don't have anything back. Go ahead.
I was gonna say, if you take out the 1% fees, purely adverse to a former client, so they're directly suing a client.
Yeah, but see, that's interesting. So, what you're saying, it sounds more like directly adverse because you're just going against them that's unrelated. Materially adverse, you're asking this question, do you have information that you could use against Home Enterprises if it's a former client? And notice what it says in this problem. Computer consulting services have nothing to do with the bond purchase 5 years ago. So materially adverse, you have some type of information. And we're not talking about moving to a different firm or anything, so we have to presume that the confidential information that a lawyer normally would obtain in this bond purchase could be used to the material disadvantage of the former client. And this just seems like the collection of an unpaid debt. So it's not the same as substantially related. It says completely has nothing to do with that. But we might have a situation where this is a former client, and we don't even need to get informed consent because it's not materially adverse, not the same as substantially related matter. But notice, this is what your response was good because it's sort of, since we don't have a definition of materially adverse, you just illustrated what directly adverse and materially adverse, how you make that distinction. Directly adverse, you're going against that current client. Even if the matter is wholly unrelated, the current client should suspect that you're not going to go against that current client's interest. Materially adverse, the time period has gone, we're not really on a formal relationship, but we still have this overarching duty to preserve confidences. And so the question is, in a formal representation, is the information that you have, is it usable against that former client in a way that is disadvantageous to that former client's interest? So you have to look at 1.9c too. And 1.9c says, a lawyer who has formerly represented the client in the matter and whose present or former firm has formerly represented the client in the matter shall not thereafter use information to the disadvantage of the former client. And so that's what we are concerned with. So let me sort of set up this next problem and then leave it there because we can't do it. Toxic waste. This is an actual case where this company moved for disqualification of a law firm. And so a number of different facts here, but so you have to analyze this critically, but I just want to point out one of these facts. On page 346. So the state wants us to represent it in a suit against NCC. This is an environmental lawsuit. NCC is a multi-billion-dollar chemical company. And the state wants us to represent NCC. But there's a complication here. We formally represented NCC. But that representation was 20 years ago. And there are a number of factors. And so when we come back, I'm going to ask you to sort of point to the factors that you're going to have to analyze to see what information the attorney had. You have an attorney who retired who worked on this. He's gone. We have a senior partner now who was an associate who worked on this, but she may not have the expertise to talk about this matter. The firm has no records. And we have to figure out, would there be a conflict in us taking on the representation of the state against NCC? We'll pick up there too. That's what we get. That's on page 345.